Okay, class, so I'm going to discuss 10 things, 10 important things, basic things, but important things about the Indian Contract Act 1872. But before I discuss such things with you, I would like to at least show you first how does this act look, how is it printed, how are all the provisions provided. Okay, so let's quickly have a look. Okay, class. So here is the Indian Contract Act 1872. Let's quickly have a look. What does it say? It says arrangement of sections, and then it says something called sections, and it says preamble. Here, look at this. These are numbers. These are called section numbers. And what are these called? These are the name of the sections. Not just that, class. There is something called chapters also. But as you will find out later on, nobody talks about chapters. Why? Because look at chapter 1. Is it starting from section 1? No. Section 3 to section 9. Chapter 2, section 10. So class, there are 11 chapters in this act, but only sections are important. Section numbers and section names are important. Okay, so let's quickly look at chapter 1. I'm not going to look at all the chapters and all, but at least in the beginning we would just like to find out how does it look. So, of the communication, acceptance and revocation of proposals. So it is talking about proposals. Okay, so looks like that there is a proposal here, and then there is something called proposals and acceptances and revocation, and then again acceptance must be absolute, so on and so forth. Chapter 2 talks about contracts, voidable contracts and void agreements. So a lot of things, as you can clearly see, what is coercion, what is undue influence, what is fraud, what is misrepresentation. Lot of definitions of these words are given in this particular chapter, or let us forget about chapters now, in all these sections. The section 10 class. Section 10 we will figure out and we will write in greater detail as a later point of time. Right? Section 10 says all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void. Okay, so yes, when we talk about sections, we will have to memorize, we will have to write, we will have to memorize important sections later on. And all of this study of law is about the interpretation of the provisions given under different sections of different acts. As simple as that. We are going to discuss a lot about it, but for now let us look at how it looks. Okay, so good. We have reached section 30. So one thing in our mind should be how many sections are there. Okay, so then we talk about contingent contracts and performance of contracts, and then we go further down. So many sections are there, and then we talk about relations resembling those created by a contract, and there is something called consequences of breach of contract. Section 75. Section 1 to section 75 talks about proposals, contracts, so on and so forth. And after that, class, surprise, section 76 to section 123 repealed. It does not exist. The name is sale of goods, but it does not exist in this act. We will discuss why not. Then comes something called indemnity and guarantee. So these are special type of contracts. Section 124 onwards, and it will go all the way, class, to section 238. Section 124 to section 238 is all special type of contracts. And again, surprise, chapter 11, last chapter 11 talks about partnership, but all the sections 239 to 266 has been repealed, schedule repealed. Okay, so total number of sections how many? 266, but many sections are repealed also. I'm going to discuss all of that. And then what? Over? Not at all. This is just about the section number and section name. It's like a table of content, class. That is when we start. The rest of this stuff, you see here, the Indian Contract Act 1872, Act number 9 of 1872, Preamble, whereas it is expedient to define and amend certain parts of the law relating to contracts, it is hereby enacted as follows. This is language, right? So this act may be called the Indian Contract Act. First section, it was about short title, extent, commencement. It extends to the whole of India. This is the extent. And when it did it come in force, it shall come into force on the first day of September 1872. Enactment or commencement. Okay, fine. Similarly, we go to section 2 and it says about interpretation clause, and there it says that subsection A, it says that, hey, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such an act or abstinence, he is said to make a proposal. So that is where we are going to write it later on. You also have to figure it out. How will you be able to talk completely like an expert and as a lawyer, right? When we discuss law, when we study law, we will read it the way it should be read. We will study it the way it should be studied. Alright, okay, fine. So then other sections and subsections and so forth, and then finally, all the sections will be covered. So this is how the Indian Contract Act 1872 looks. Alright, so back to 10 basic things about the Indian Contract Act 1872 class. Okay, class. Fine, so let's get started. Okay, we'll get started. So number 1 class is the something called name. So what is the name? Name, sir, why do I need to remember the name? Name is the Indian Contract Act 1872, no? This is a name class, correct? Absolutely not, right? When we talk about law, we have to talk about an English which is certain. And specifically when we talk about all these words, they must start with capital letters, class, okay? I cannot write specifically act, I cannot write ACT. That act means something else. Just that the letter will become capital letter or a small letter, it will make a hell lot of difference. Yes. Right? So definitely not, you will say. Absolutely not. When we have to write the name of the contract anywhere in all your answers, ensure that you are writing it just the way it should be written. That's the title of the act. So it has to be written as per the title. Okay. Fine. So the second thing what do we need to know, class, is about the date of enactment. When was it enacted? When did it commence? When did it come into force? What was the date of commencement? Enactment. When did it come into force? Okay. So date of commencement. So we know that, right? We just looked at that act, right? 1st September 1872. So we will have to keep that in mind. Okay, so that is the second point, sir. Okay. And always, class, the section 1 always means, let's not be so. So almost all the time, section 1 also talks about the applicability, the extent of the contract of any act. Okay, so I will talk about extent. So class, the Indian Contract Act 1872 is applicable in Africa. Is it applicable in America also, London also, Singapore also, everywhere? No, boss, it is the Indian Contract Act and the act will say where it is applicable. Okay, so what is the answer? Oh, India, sir. Indian Contract Act, India. Okay. Now wait for a surprise. It is the whole of India except the state of Jammu and Kashmir. Okay, are you having a certain kind of feeling, a certain kind of emotion that why, sir, why this JNK thing? Plus, JNK, Jammu and Kashmir, enjoys special status under the Article 370 of our Indian Constitution. Okay, in that special status, a lot of things are different for the state of Jammu and Kashmir. And one thing that is also different is that the Indian Contract Act 1872 applies on all other states of this country except that state of this country, which is called Jammu and Kashmir. Why was it so? Why, sir? Hmm? Why like this? Plus, did you know that this is this is really something that is a very controversial topic, and anybody can get absolutely emotional and sometimes agitated when we talk about this. But let's go back to history quickly and figure it out why this was so. So, Jammu and Kashmir, you may already know this, but just hear me out. So, Jammu and Kashmir at the time of independence, it was being ruled by somebody called Raja Hari Singh, and Raja Hari Singh wanted Jammu and Kashmir to not go to India and to not go to Pakistan. He wanted an autonomous place. He wanted a separate country also. Correct. But he knew inside that it may not be possible, but he wanted that effectively. Okay. So when India approached Raja Hari Singh saying that let us just get integrated and we will be a bigger and powerful and all that force will become whole India, Raja Hari Singh said, no, I am not interested. India said, boss, everybody is together. Look at East India, West India, South India, North India, everybody is together other than you. And if you don't come to us, you will always face problem with your neighbor called Pakistan. But Raja Hari Singh did not listen to us. Fair enough. And India left it just like that. And then Pakistan pounced upon that opportunity, and it was almost about to attack Pakistan when Raja Hari Singh came back to India saying that, boss, earlier whatever I had said, but now I would like to become a part of the state of India, right? But I have one condition. Now, India also didn't have too much chance. That is one thing. Second thing is India was being ruled by somebody who was very benevolent, very statesmanlike. Okay, and it was possible that had India not agreed to that, today the life of country would have been much better. If you are hearing this video and if you are a part of Jammu and Kashmir and if you do not agree with me, I am okay with that so far. But overall, I believe that I am a truly patriotic Indian, and therefore I believe that the state of the Jammu and Kashmir should completely belong to the Indian territory, and all acts should be applied. But anyways, let's go back to the story. There, Indian state agreed. The state of India, the country of India, it agreed with Raja Hari Singh that all the laws that will be passed in the country of India, which will be applicable to all the states, will not automatically be applicable to the state of Jammu and Kashmir. Those laws must be passed by the state of Jammu and Kashmir before they become law in that state as well. So all the assemblies here in India, they passed this particular act. However, Jammu and Kashmir did not pass it. So it's not the case that Jammu and Kashmir does not pass all the laws. So recently, the Goods and Services Tax Act was passed in Jammu and Kashmir also. But is this the case with the Indian Contract Act that it has not been passed in the state of Jammu and Kashmir, and therefore this act is applicable to the whole of India except the state of Jammu and Kashmir. Okay. Okay, class. One also very important thing that I would like to talk here is about how do we read the names of sections. Okay. So, class, we know that the act is made up of sections. That much we know. But what if there are different points under a section? What are they called? They are called subsection. Okay. And what if under each subsection there are further points, bullet points, let us say? Bullet points will not be there, always there will be a number because we need to refer. When we need to refer, bullet points will not be there. But other points are there. They will be called class clauses. And what if under that, so this is the last stage, what if under that they will be called sections and subsections, clauses and subclauses. Clauses and subclauses. Okay, so from here onwards, promise me one thing, that when you see something written as per section 2H, correct? No. So promise me something that when you read this, you will read it as it should be read. Okay, section 2 subsection H, as per section 2 subsection H. Okay, if there is something after that, you can say section 2 subsection H clause 5. If there is something after that, you can say section 2 subsection H clause 5 subclause 1. Class, it does not exist. I am just giving an example here. Okay, section 2 subsection H only exists. There is no further clauses in that, but I am just giving an example that section, subsection, clauses and subclauses. And what is written under that? What is it called? Whatever is written under that, what are they called? It's called provisions. Okay, they are called provisions. So as per the provisions of section 2 subsection H, or agreements, an agreement enforceable by law is a contract. Okay, anyways, we will see a lot of examples like this, but how are we saying that? As per the provisions. Provisions means inside that of section 2 subsection H. Okay, fine. Alright, so we are going to do that, no problem. So that is number 4. What is the number 5th? So number 5th thing, class, to remember is we are going to discuss something called organization of the Act. Organization of the Act. How is it organized? That we are going to look at. Okay, so I hope you saw when I was looking at the Contract Act and you figured out yourself, right? So we said that, hey, section 1 to section 75, right? This relates to what? Relates to general principles of contract. General principles of contract. Okay, fine. Section 76 to 123, class, it related to sale of goods. Originally when it was enacted, those sections were related to sale of goods. 76 to 123. Okay. Section 124 to 238, class. They are related to special type of contracts, and we are in this particular mostly at the foundation level, at the level when you are giving the first level of your exam, mostly section 1 to section 75, all about the general principles of contract students have to study. In some cases, it is possible that the syllabus requires you to study more sections. So we'll definitely cover section 1 to 75, but we'll also cover, if required, more sections as per the syllabus. Okay, so special type of contracts. Okay, so we will figure out what are the special type of contracts. So right now I'm not going to go into detail, but names are like what? Bailment, guarantee, right? Pledge, contract of agency, so on and so forth. Indemnity. Okay, so that is section 124 to 238, and then we have section 239 to 266, and this one is about partnership business. This was when the law was originally enacted. Okay, so over a period of time it became a very bulky act. Also, the provisions specifically for sale of goods and the provisions for partnership business, they were inadequate. They needed more revision. Okay, so what happened was that these sections, the sale of goods and partnership business, these sections were repealed from here and two separate acts were passed. Okay, fine. So this was sale of goods and partnership business was, they were repealed from here. Okay, repealed. The Sale of Goods Act 1930 and the Indian Partnership Act 1932 were enacted, and provisions for those provisions in the Indian Contract Act relating to those acts were repealed. Okay, there was a fifth point to remember. Let's go to the sixth point now.